Już? O, już.
परवीन जी नमस्ते। राजेश जी
अदुकिया साहब नमस्कार।
नमस्कार।
आप ही का
नमस्ते
इंतजार।
सर, राम राम।
राम राम। विनीत साहब नमस्ते।
नमस्कार नमस्कार भाई साहब नमस्कार।
सर नमस्कार। नमस्कार सर।
आर के श्रीवास्तव जी, महादेव, सौरभ जी,
हरप्रिया जी।
विनीत साहब आपका दिल्ली रहना है कि ज्यादा जोधपुर?
नहीं, रहता जोधपुर हूँ। दिल्ली और बॉम्बे हाई कोर्ट अभी मैं एक अपीयरेंस के लिए आया था, एमपी हाई कोर्ट में गया। अदर हाई कोर्ट्स वेयर आई हैव नॉट बीन एजेड, मैं जा सकता हूँ, जाता हूँ।
पूरी कर दे आवाज।
तो थोड़ा बहुत ठीक है। आर्बिट्रेशंस के अलावा भी ये कुछ काम।
सही बात है, सही बात है।
सर गुड इवनिंग टू ऑल सर।
गुड इवनिंग श्रीवास्तव साहब।
कोठारी साहब
नमस्कार सर, प्लेजर।
अडुकिया साहब
गुड
सर
इवनिंग।
नमस्कार।
प्रवीण जैन साहब नमस्कार। अडुकिया साहब हमारी आपकी मुलाकात, इफ यू कैन रिकॉल, जब आईबीसी शुरू ही हुआ था, दिल्ली में कॉन्फ्रेंस हुई थी एक बार, तब हम लोगों की पहली मुलाकात वही हुई।
एसोचेम की कॉन्फ्रेंस थी, सबसे पहली
Yes, yes,
कॉन्फ्रेंस
yes.
थी।
we met there sir.
या
आप कहाँ बॉम्बे प्रैक्टिस करते हैं श्रीवास्तव साहब?
नहीं सर, मैं एक्चुअली आई वाज अ लीगल हेड इन सेंट्रल बैंक ऑफ इंडिया, सो आई टुक वीआरएस एंड नाउ आई एम प्रैक्टिसिंग इन दिल्ली हाई कोर्ट।
दिल्ली हाई कोर्ट। तो दिल्ली रहना दिल्ली होता आपका?
हाँ दिल्ली सर, एनसीआर दिल्ली, इंदिरापुरम एक जगह है, जस्ट
I have heard about it. Yes.
Yeah. So I am staying there, sir. So I have now started practice. I belong to an advocate's family. My father was an advocate, brother is an advocate. I was an advocate, and I got sir selection in RJS.
Okay.
In 1995. Then that process was stayed by the Honorable High Court on the petition by the OBCs. So my destiny was bank. So ultimately I joined the bank. But again, I took VRS and joined the profession again. I have come back to my original.
How many years you have been now in bar, sir? Again?
Earlier, sir, I was in bar for 8-9 years. Now, then thereafter, almost 25 years, and I was in the bank. Now, from April 2022, I have started again. Sir.
Very good.
I was having yet 4 years to go, but I took VRS. Sir.
That's what generally people do if they want to come. So I served 16 years, 4 high courts, and 20 years practice as lawyer, a CACS, PhD in tax. And,
oh, great, sir, great. So vast experience and exposure of all the fields, sir.
Experience, of course, I got good experience in 4 high courts.
Yeah.
Nipun from Ahmedabad, I think is in the screen. Namaste, Nipun, how are you?
Namaste sir, very nice to see you sir. Thanks for accepting the invitation at short notice sir.
My pleasure, sir. My pleasure.
सर नमस्कार। निपुण जी
Yes,
नमस्कार सर।
please.
नमस्ते जैन साहब, नमस्ते श्रीवास्तव जी।
नमस्ते सर, नमस्ते।
निपुण जी आप स्टार्ट करेंगे जरा?
जी।
हाँ निपुण जी।
जी सर।
हाँ प्लीज स्टार्ट। आप स्टार्ट करेंगे? इंट्रोड्यूस करके ना जस्टिस साहब को।
सर आई थिंक आपके पास प्रोफाइल शेयर्ड होगी।
यस जस्ट
जैन साहब आ गई है मेरे पास।
ओके सर, मिल गया सर।
स्टार्ट करें?
हाँ यस सर।
A very good evening to all the participants and thank you very much for gathering in huge numbers. It's our privilege that we have Honorable Justice Kothari sir with us as guest of honor, and I have been closely seeing him in Gujarat High Court and various other high courts, and it's always a pleasure to hear him and learn new things from him. And I think that we will also be moving on the same way, as from a CA he turned into a lawyer, then judge, and that's how the journey starts. We have with us Adukiya sir, similarly CA turned lawyer now, and another guest of honor for us, and regularly he has been guiding us as a central council member. So I welcome you both, sir, and I would request Justice Kothari, sir, to say few words for a deliberation on alternative dispute resolution, the upcoming professional opportunity for all of us. Over to you, sir.
Thank you, Nipunji, and my dear colleague Rajkumarji, doctor, whose degrees have at least 3-4 lines below his name. So I'm yet to comprehend how much qualified vastly he is.
Thank you.
Advocate Srivastava Sahab from Bank Services, CA Pravinji, Nipunji, Vishalji Dave on the screen. Friends, it's a pleasure and honor for me to be part of this webinar on the topic of ADR, which undoubtedly is a very, very important wing of judicial dispensation. I have been chairman of ADR centers in 2 states, Madras and Gujarat. And besides Lok Adalats held for quicker disposal of cases on all the Saturdays, we had started almost a drive kind of thing to refer the matters to arbitration and mediation. It's still more preferable in a way because the difference between adjudication and mediation, as you know, is adjudication and mutual settlement. So this is all done to remove the blockage of the piled up cases in the court system, where the Indian legal system, we all know, is a hierarchy of 3-4 tiers of the remedies. And in that process, with the sheer bulk and lesser size of the judiciary, the things get delayed. And therefore, the system of ADR, alternative dispute resolution, or you call it appropriate dispute resolution, Section 89, now new law is coming on mediation, etc. All these things has become not only a matter of current hot topic, but is of utmost importance. And even chartered accountants, I would recommend and suggest, can play a very vital role, because I am part of some of the committees of the institute in the head level. And I've been advocating the cause of chartered accountants being allowed to appear in the constitutional courts also, at least in the economic matters, banking matters, and these kind of matters, where their wisdom, their knowledge can definitely add value to the system. And this is why I myself belong to the Institute of Chartered Accountants. Therefore, it's always a happy experience to go back to that alma mater and recall with pleasure that how lucky we are to assemble in such a great learned people's assembly. And even today, when we discuss the somewhat finer points of arbitration and conciliation and mediation also, I think we'll take this talk further. And this is how I would like to give an introductory note from my side. Thank you very much for inviting.
Jen, sir, now I would request you, Adukya, sir, for a few words, and then we will start with the main session.
Yeah, thank you, Advocate Nipun Singhvi ji, Justice Dr. Vinit Kothari ji, other friends, Parveen Jain ji, Advocate Srivastava ji, and Mahavir ji, and colleagues. You know, this subject is, I find this is the simplest law out of 1300 central legislations, the Arbitration and Conciliation Act 1996, the smallest and maybe one of the legislation where there are no rules. Similarly, we have a mediation bill in the parliament, select committee report is out, and shortly we will have a mediation act. So the ADR, alternate dispute resolution. Now, National Judicial Data Grid gives the statistics that there are 5 crore cases pending in different courts. और ADR का मकसद क्या है? मियाँ बीबी राजी तो क्या करेगा काजी? The parties to the dispute, and this is one position which we call arbitrator. There is no qualification required. There is no education required. There is no minimum capital required. So what I have learned, 7 alphabets I will explain, and then I have made an acronym, PMI, Prime Minister India. Online payment, because our Prime Minister likes online payment. Present value. P is passion. So we will be very successful in ADR if we have that passion of, becoming ADR expert. M is mindset, second alphabet. We should be opportunistic. When somebody comes to me, suggest me an advocate, then I ask that person, give a brief background of your case and why you are not going for mediation. First, negotiation. There are 3 men, where parties to the dispute themselves resolve. Then mediation is a assisted negotiation. Conciliation is nothing but a mediation. So once we will have a mediation act, this 21 sections 61 to 81 will go out of the Arbitration and Conciliation Act 1996. And the arbitrator, it's a Latin word, arbitrar, where it means a judge outside the court. So the 7 alphabets which I was trying to say, passion, mindset. Third is I is a income. We should have active income and passive income. Passive income will come when you create an online course on ADR, when we create a book on ADR and there are royalty income. O is opportunity. This is one subject which is a global subject. All 192 countries of the world, one can practice as a arbitrator or ADR practitioner. This work will happen by purgence, very extensive purgence. Purgence I divide into 2 parts: physical purgence, present value, physical purgence. So you go to Chamber of Commerce, you go to community forums, you go to all other rotaries and other things. You speak about the advantages of ADR rather than going to the court. And V is a virtual purgence. So there are more than 30 social media platforms. Put a posting every day, the advantages, ADR, explain different concept, mediations, all disputes. Like this Ram Mandir was resolved through mediation. And dispute is such a subject which takes place as soon as the child is born. Like उस समय dispute ये होता है, mother कहती है ये नाम रखना है, father give a different name, बुआ gives a different name. So there are differences of opinion. So dispute will be there, or differences will be there till human lives are on this planet. So this is going to be a permanent subject. And it's a very interesting subject. It gives a lot of value addition to the, the whole community, because once dispute is resolved, they are able to do the activity together, business together, live harmoniously. So each one of us, we must actively play our role in ADR. Thank you to Gipa and Parveen Jainji for giving me this opportunity. Currently, Institute is doing 26th batch of ADR. We started in this week on Monday. So, and there are many other certificate courses on ADR done by universities, other institutes. For mediation, one need to do a 40 hours course. Parveenji and myself, we were together in a batch, to my understanding, of the Indian Law Institute for the mediation. And each court has a mediation panel, an arbitrator panel. Because in Code of Civil Procedure, in all laws, before giving a judgment, the judges have to explore, the tribunal members have to explore whether parties are ready to settle the dispute among themselves. Thank you.
Sir, please explain about opportunities for professionals about future of ADR, so that they can encourage for.
See, future is it is a sky touching future. See, what we have to do. There are two kind of work. One is a empaneled work. So there is a Indian Council of Arbitration. They have a panel. We have a Nani Palkiwala. So there are arbitral institutions and there are mediation institutions. So there is an Excel sheet prepared by us, which I will be sharing, Parvinji, with you now only. So which you can share among participants. That is one.
Okay, sir.
Second is ad hoc arbitration. Ad hoc arbitration is one where parties to the dispute will appoint a person. And you know, sometimes we have a notion, 10 years, you know, that 8th schedule to Arbitration Conciliation Act is no more there. It is repealed in 2021. So every person can be an arbitrator. And this work will come, and see, the work teaches us how to do hearings, how to fix meetings, how to draft an arbitral awards. 3 principles of natural justice which applies. Self should not be interested in the subject matter which one is presiding as an arbitrator. Second is the arbitrator should not be biased. And third is, you know, there should be an opportunity of, you know, hearing on both sides, and there should be a reasoned arbitral award. So, Parvinji, the opportunities are unlimited. It is besides us. It is next to us. We are not seeing the opportunity and we are not seizing
Thanks
the
so
opportunity.
much. Thanks, sir. Thanks a lot, sir.
Thank you.
And I request to Justice Vinay, please share your experience more about some more more words.
Yeah, thank
Sure.
you. Jyoti. Actually, I have been doing arbitration only after my retirement last year, 1 year or so. But yes, I've dealt with this subject extensively as a lawyer and as a judge on the bench also. My experience is that, of course, if you put arbitration and mediation in a comparative situation, I would rate mediation as a better remedy than arbitration also. The advantage which I see in arbitration over mediation is that the power of the arbitrator is to adjudicate. Because in mediation, it is purely mutual consented settlement, which may or may not happen sometimes. Of course, the trained mediators help and facilitate the mutual settlement process. But then arbitrator has a power to adjudicate the issues also. Therefore, even though the arbitrator can be anybody like a former judge or a advocate, chartered accountant, whatever, company secretary, engineers also, or even professors, but they should have a broad framework of the procedure also. Because most important in the Arbitration Act is to comply with the principles of natural justice. If you do not comply with the principles of natural justice, do not afford adequate hearing to the parties, then your award or the decree or the judgment which you give as arbitrator is likely to be set aside only on that ground. And then the parties are back at square one. So a judicial trained mind will always be better as an arbitrator, even though other professionals, if the particular nature of contracts like engineering contracts, bridges, dams, etc., requires that kind of background of the arbitrator also, it can be appropriate sometimes to have engineers also as arbitrator. And now the law permits that if the sole arbitrator is not to be appointed by mutual agreement or cannot be appointed, then there is a tribunal of 3 members, one to be appointed by both sides, parties, and then the 2 arbitrators appoint the 3rd umpire or the presiding arbitrator, which 3 by majority can give a judgment. Now, my experience as a judge in arbitration was mostly under section 37 and 34 of the Arbitration Act 1996, where the parties on limited grounds can come to the court. Otherwise, the court's interference in the arbitration is intended to be and even statutorily provided to be very, very minimal. But what happens that once the award is passed, even on those limited grounds like breach of principles of natural justice, etc., the matters are taken to High Court or District Court if the this District Court has jurisdiction against the commercial court of the lower level. Then it takes its own time. Once you enter the annals of the court system, the very system cannot deliver quick justice. That is the unfortunate part of our Indian legal judicial system. And the remedy, of course, are many, but it is necessarily in the ball is in the court of the executive, who can provide a much better, much larger infrastructure for court system. And arbitration is not is a very big bulk of work in the high courts, and therefore they are not given that kind of priority. A judge normally dealing with civil roster deals with the arbitration cases also, including section 11, section 34, 37. By and large, all high courts have this system. Now, even though the grounds are limited, people challenge, and you have to serve the notice to other side. Both sides are to be heard. Then the judge has to apply his mind and say finally that no, there is no ground made out for interference in section 34 and 37. 37 is appeal against section 34. It has to be dismissed. But if in the meanwhile it takes 4, 5, 7 years, the very purpose of the fruit of the decree, which the arbitral award gives, is deprived. So execution cannot be undertaken till section 34 or 37 is pending. Enforcement cannot be done. Therefore, it's like a hanging fruit. You have the fruit, you have the decree, which should, as per the time frame provided in the act, should be within 12 months. But there also sometimes some delays happen. But most of the arbitrators try to expedite. And I believe my experience as a arbitrator now at domestic level and international arbitration I have not done so far, but I am likely to be empaneled by Singapore and Dubai centers also very soon. So I think even that experience will be a very value adding to my experience as an arbitrator. So arbitration is effective, efficient, and most desired bypass, like heart surgery. What do? You bypass the system, create a new vein in the heart, and the blood flow increases. Likewise, ADR system, including mediation and arbitration both. Actually, section 5 provides for 5 remedies ADRs, but mediation and arbitration are most popular. Judicial settlement, lok adalat, etc., different matters. So arbitration should be encouraged. Now, the problem I'll tell you in the practical field is that lawyers and parties, either out of their ignorance or simply do not want to go to this ADR system. They want the judgment of the court. Now, court judgment takes its own time, and there are appellate remedies further. So all these things add up to the time, and which is very, very important, because the time has the great value. So if the time is more taken in the resolution of the dispute or a final decision, then the very purpose is lost. Therefore, arbitration should be encouraged. Section 8 mandates that the court is bound to refer the matter to the arbitration if the agreement contains a clause of the arbitration, because section 7 requires mandatorily a written arbitration clause or written arbitration agreement for invoking the arbitration procedure. And therefore, the party should be educated, encouraged by the lawyers, chartered accountants, and their counselors to go for arbitration first. Now, these days, the trend is that in the agreements, even besides arbitration clause, there is a clause above that, amicable settlement. Now, amicable settlement obviously refers to mediation. And you do not need even a trained mediation or the institutional mediation there. Even the parties can sit across the table, thresh out their points, and go for a settlement, reduce it to writing, and then go to the court and say, please convert it into a decree. So that can also be done. Now, all these ADR systems are intended to be there with a very pious and great objective. The problem is implementation. The problem is of choice. People do not want to go for it for unknown reasons. I mean, professional interest, even of the lawyers and counselors like chartered accountants, will be, in my opinion, served far better. A satisfied client, a client getting early dispute resolution, will be more willing to give you more cases. So it is wrong to assume that if I get it decided quickly, then my case will go and then I'll lose my fees or whatever. So ADR system is very good. It should be encouraged. The law 1996 is constantly being amended to fall in line with the international standards, international requirements. This 1996 Act itself substituted 1940 Act in terms of the UNO model law, UN Citral model. And now 2015 and 2019 major amendments to this Act have made it more effective. Therefore, all the professionals should know that what is the trend of these arbitration laws and arbitration agreements and arbitration, like institutions like ICA, Institute of Indian Council of Arbitrations, of which I am also a life member. They even publish model agreements for arbitration, model clauses to be put in the agreements between the parties for any works contract. So you should educate yourself, you should educate people, you should educate businesses that how to incorporate in the agreement. And unfortunately, if the dispute arises, best is that the dispute does not arise. But if the dispute arises, which is sometimes bound to arise because of conflict of interest between the various angles of the contract execution, then you should go for the mediation first, and then if you cannot settle there, arbitration. So this is, in a brief manner, my view on the ADR system, which I strongly recommend.
Means we can say arbitration to be followed by mediation.
No, mediation to be followed by arbitration, because mediation is the first step which the party should take for amicable settlement without intervention of any court legal system.
Okay.
Because there is no power of adjudication with the mediators. They just guide you, train you, help you, educate you to arrive into a settlement by your own consent, by your full understanding of the dispute, and then do it. If you cannot do it, then go to the arbitrator and get it adjudicated, because award of the arbitrator is like a decree of the civil court. And therefore, arbitration should be second step. Third and last should be court. And in the courts, as I said, if you enter the courts at lower levels, like by way of a civil suit, your third generation will see the final result. So what is the use of going to that system which cannot deliver for 3 generations? So therefore, the most desirable and attractive proposal for the judicial dispensation or resolution of dispute is undoubtedly ADR. Yes.
Thank you, sir. Thank you, sir. Good. I invited to say advocates R.K. Srivastava to highlight some issues and role of ADR in banking and financial sectors. Please, sir.
Sure. Thank you very much to GPA for giving me this opportunity to be the part of this webinar. Good evening to all. Good evening to Honorable Justice Johari Saab and Dr. Adukia Saab, and my co-speakers, Mr. Birla and Mr. Singhvi Saab, and all the friends who are joining this webinar today. See, I will take forward what Honorable Justice has just said, that mediation and the arbitration. See, what I personally feel, sir, mediation should be given more focus than the arbitration. The reason being, what Honorable Justice has just said, that arbitration is again more or less, it is like a litigation. Once, because there is an adjudication in the arbitration. But in mediation, there is a consensus of the parties to arrive at a particular settlement. So in this situation, you will realize that both are having a win-win situation. There is no heartburn. Even in the case of arbitration, I mean to say adjudication of a cause, there may be a heartburn to any of the parties. But in the case of mediation, it's a win-win situation. Both the parties have to sacrifice something and both the parties will get something. And yes, mediation is also given a legal framework. It is also having a legal gown, so it's having the same value. Now, I will take my, I will share my experience as I had been a banker for a long time. if you see in the bank, there are multiple areas of litigation, such as a recovery part, number one. The major part is of a recovery litigation. Then second, what I felt, it was a HR related matters, human relations, HRD related matter. Then third, it comes premises matters. Because banks are having so many branches and every branch's property is not owned by them. It is, there is some landlord with regard to the property. So disputes more or less come with regard to that property as well. Then again, a major chunk that is with regard to the consumer forum cases. Consumer forum cases are again in a good number in the banks. And then the other miscellaneous matters we can say. But sir, what I have seen in the bank as a legal head, though we are having mutual decision agreements or say mediation, amicable settlement clause, and also the arbitration clause in each and every agreement, banks enter into so much agreement with the various parties. Most numbers what I have seen in my tenure is with regard to the IT matters. We are taking the software, we are taking the hardware, we are taking some license, we are taking some program, but the number of cases are there. Service level agreements are there, and each and every agreement there is a clause of arbitration. But surprisingly, if you see the litigation portfolios of the bank, the arbitration cases are very less. Very less, though after having the clauses, but matters are much lying in the courts. So what Sir has said, Johari Sahab has said, I feel it is correct to some extent. Why I am saying so, that either there is a lack of knowledge or there is lack of willingness. Sir, what I feel, both are the reasons as far as banks are concerned. Lack of knowledge, yes, how can I say? In our bank, I have seen the situation where party has invoked the arbitration clause. Party gave us a notice, okay, you propose a name of an arbitrator. We have to propose a name of arbitrator, then there will be umpire arbitrator. And our bank, our department concerned was not at all aware what to do in that notice. They kept mum on that notice. Ultimately, matter went to High Court, then High Court directed and appointed them. So this is the lack of knowledge. This is the lack of knowledge. And now I come to lack of willingness. Sir, if you could recall the Honorable Justice Sikri Deedan of Supreme Court, he has referred that, and if I'm not wrong, Justice Ravindra Bhatt has also remarked in one of his judgments that government officials wants that decision should be taken by the courts, not by them. Whatever decisions they can take, they want that should be taken by the courts. This is, I think, one mindset as far as the bureaucrats or the government officials are concerned, or the government offices. I include banks also in them. What happened? See, in banking system, there every decision of a banker is under a scanner. We don't know at what time CVO will come, at what time some EOW will come, and they will say after 10 years why this decision was taken at that point of time, why it was not taken in this fashion, why it was not taken in that fashion, because they are examining the matter in the present scenario, and the decision was taken by a concerned fellow in the scenarios prevailing at that point of time, which they are not in the position to just visualize what were the situation before the person who took the decision. Then what happens? Everybody wants, okay, let it be shifted from me. Yes, if court will say it's fine, then nobody can question my decision. This is, I think, one of the major reasons where the banks, but in banking scenario, I'm saying, they are taking a call. So as an advocate, I am also looking where a person who was an employee of an ex-bank, he was terminated from the bank. The bank subsequently merged with another bank. And now that person is asking some relief. Okay, you give me a relief which otherwise you are giving to your terminated employee. Why you are not giving to me? but we want a court's decision. This is the mindset which I am telling, which I feel as in the banking sector, it is, I think, one of the reasons which is causing some hindrance. See what sir has said. One thing is there, the judicial system. Yes, we know how the things go in our judicial system. And another thing, what I feel is the mindset of the officials. Now,
Can I
sir,
just make a small intervention, sir? You have put a very valid point. Firstly, I may correct, I am Johari, not even of diamonds, I am Kothari.
sorry, sir.
Secondly, you have raised a very important point that in government, for variety of reasons, I would say, the proper authority is not given to the officials to enter into mediations and negotiation arbitrations. And that is why it suffers. And that is in the courts we know, and you also know, being part of the system, that 70% of the litigation is either against the government or by the government. And out of that 70%, if even a broad guess is made, 25% of that litigation can definitely be offloaded if they have properly laid down guidelines and power structure with their officials, giving them liberty to enter into ADR system and get the settlements done. Unfortunately, nobody in the government is even applying its mind to this aspect of the matter, despite judgments like ONGC's case, where the Committee on Disputes Resolution etc. was created, and the public sector undertakings and the departmental of the governments were asked not to fight amongst each other in the court of law. Even that judgment has not worked. And government department inter-se also fight, PSUs inter-se fight, PSUs fight against the government. My goodness, I myself rendered a judgment in which, citing ONGC's case, I rebuked the public sector undertakings. How dare you come to the court against the government? You are part of the government. You are a government company under section 617 of the Companies Act. Why don't you go to the concerned ministry and sort it out? Now, doing all this also doesn't bring good sense. God knows how can it be brought. But if the proper guidelines are laid down, much of the burden of the courts can be offloaded, definitely, because government is a major litigant in the courts.
That's very true, sir. That's very true. That's very true, because we also feel in many of them, when I was in a bank, then we had a litigation policy. We took it to the board, and in the litigation policy, we had a chapter out of court settlement. Yes. And which authority will take a call? Because now it's a board decision. So nobody can question tomorrow how this person, we have given the discretion to the authority concerned, approved by the board, how he is to take a call. So, but sir, even then, what my submission is, sir, we are very much hesitant in taking decisions. We are very much, being a government officials, we are very much hesitant.
We want to shift it to the others.
We want to shift to the court. Let there be a seal of the court. I'm happy.
Yes.
This is what now, sir. Now banks are, see, there is one area where banks are entering into compromises in the recovery matters or the NPA matters. So banks are having their in-house committees where even retired high court judges are also the members of the committee. In Mumbai, in our office, where in my earlier bank, there is a committee which examines the compromise proposal of a party, and then in the committee, high court judges are also the members. Now, see the approach. What I personally feel, that is out of record I am submitting, my personal approach, we want some legal person there to save me for any dispute which may arise tomorrow. No, sir, judge sahab bhi the ya vakil sahab bhi the, and sir, hamara isme aisa, there was nothing. So, and this is what Honorable Justice Sikri has suggested also in his judgment. If you want to take some shelter, why don't you have the retired judges or advocates in your committees and that? Now, sir, the issue is, see, now myself being an advocate, so I feel this today's webinar, how the opportunities are there for the advocates to get into this system and make it more effective. Again, sir, at the cost of repetition, in my humble view, adjudication again is a litigation. If you see, sir, not forget about CPC or civil matters, even by way of plea bargaining. In criminal matters, it was an effort to settle the matters out of court.
Yes.
Plea bargaining is that only. So when the even criminal law permits to settle the matter, forget about the compoundable offense and all these things. The plea bargaining chapter is purposely introduced to shorten the burden of the courts and to get the matter settled with the satisfaction of both the parties. So this is what mediation will play a very big role, what I personally feel. Now, sir, as an advocate, I feel I am having 3 roles, that is before mediation, during the mediation, and after mediation. Because yes, once matter goes to the court or the arbitration proceedings, yes, we are all in the gowns and in the courts and in the robes, and we are arguing the matters purely on a legal terms. You will see, sir, even the consumer forums which were made with the purpose to let the matters be petty matters be settled in the effective manner in the shortest time. And now we are seeing the fate, sir. The consumer forum matters are again pending for 10 years. So what I feel, sir, as an advocate, see, if 2 parties are in a dispute, then the party is having utmost confidence in his counsel. Parties are having utmost confidence in his counsel when he feels that I am in doubt or whether I should go for it or not, what will be the benefits, whether I get in some mediation or some compromise out of the court, whether tomorrow that will have some binding effect or not, whether the other party will retract to, or then what will happen, all these things. So as a counsel, I can educate him. What you have rightly said, sir, education is also a very important factor. So as an advocate, I can educate them to see nothing wrong. These are the benefits. You are going to save your time. You are going to save your money as well. And you have rightly said, now time is the most precious thing today. And even if most of the friends are CA there, see, even the debt is defined as a time value for money in the IBC itself. So ultimately, time is also a very precious factor. So we can educate, no, don't worry, you go into it. Then the matter comes during the mediation. During the mediation, what happens? Mediator can suggest them number of options. Parties may agree, parties may not agree. In that case, I feel mediator can't impose his dictate. He can only convince the parties to see this may be the outcome, it will be beneficial for you. And parties may be stuck at that point of time, okay, whether should I agree or should I not. He may not be in a position, to understand what is good, what is wrong for me. And sir, what I feel, if you enter into a courtroom, there is a psychological pressure on the party. When we see a judge on the dais, the counsels in the robes, and they're shouting arguments and all these things, there is a psychological pressure on the party, sir. His or her reflexes do not come, sir. When a judge sitting on the dais asks something a party, practically, sir, I have seen shivers. Even when my bank officials sometimes appear before the court, they were not having so much of confidence. They were having such a fumbling voice. They couldn't even say what they want to say. So this is a pressure. But in a mediation, sir, there is a friendly environment. Their party feels the suggestions are there. And when a party comes with the view, I am not bound to accept, then his reflexes are more sharp than in the pressure. But even when party may be stuck to somewhere, so in that case, the counsel can advise him to see this is right for you. Or he can suggest something. When he suggests something to the mediator and mediator thinks it gives confidence to the party that my counsel is being heard by the mediator. Then whatever, so there are most likelihood that matters may be solved there. And if it is solved, then there is a win-win situation. And if it not solved, then after mediation issues, then again, what is my role? If the matter is settled, fine, then I have to say how to draw the settlement. What are the rights? What is his rights? What are their rights? If the party fails to do, then what you can do? I can give him a comfort and a cushion. See, don't worry, even after this judgment or this order, you are properly secured. And if the mediation unfortunately is failed, no issue, then he can guide, and now you can approach the court and you can start your proceedings there. So I feel mediation should be more focused. In the banking sector, I feel, sir, once we file a suit against the party, may it be a recovery suit or if a party files suit against us, we feel we are enemies. We even do not go to the talking terms with the parties. Even sometimes when I was a legal head, I was asked a question by my field functionary कि सर केस फाइल होने के बाद क्या हम उससे कॉम्प्रोमाइज कर सकते हैं, क्या हम उससे पैसा ले सकते हैं? मैंने कहा यार एक बात बताइए, कोर्ट परमिट कहां नहीं करती, कहां रोकती है सेटलमेंट के लिए? See, this mindset is within the parties कि एक बार हमने केस फाइल कर दिया, now we don't have to talk in terms. So the counsels are there for both the parties. What we used to do in our system, sir, हम अपने वकील से ये कहते थे कि आप सामने वाले वकील को कांटेक्ट करो और पूछो कि पार्टी क्या कॉम्प्रोमाइज करना चाहती है. Let us come to the table first. So advocate's role is very important, sir. Very, very important. Very. Now question comes कि if advocate, हम एक सवाल आता था कि अगर मान लीजिए कल को advocate ने compromise करा दिया, what he will get? Ultimately, sir, we all are working for money. Yes, charity may be one aspect, but ultimately livelihood is the main object. So what Adukia sir has said, yes, if we are successful in these things, if we can give a message to the public, message to the societies, yes, we are here to resolve the matters, so parties will certainly approach. I feel parties will certainly approach, and the things will go in a smoother section. Sir, Abraham Lincoln has very rightly said one thing, that because of their skill and experiences, advocates have superior opportunities to do good. I think he wants to give a message to the society that you should follow the advocates, because advocates are the persons who guide them to fight, and advocates can be the person who can guide them to resolve. So, sir, what I feel in the banking system I have just placed, so I would conclude by saying this thing, because why I said it's a matter of mindset. If we should, otherwise, what is the हमारे यहाँ सर कहते हैं, हमारी I belong to मथुरा, तो हमारे यहाँ एक कहावत है कोर्ट के बारे में कि जो मुकदमे के बारे में कहते हैं, जो लड़ा, जो जीता वो हारा, और जो हारा वो मर गया. क्योंकि जीतने वाला इसलिए हार जाता है, वो फाइनेंशियली टूट जाता है, और हारने वाला तो मुकदमा भी हार गया और पैसे भी टूट गया, तो ही इज प्रैक्टिकली नो. सो पार्टीज में जब हम हमारे पास आती है ना, दे से वहीं से घर से चलेंगे, लड़के गांव से चलेंगे कि आई विल सी यू इन द कोर्ट. दिस इज द माइंडसेट. आई थिंक वी एज एन एडवोकेट, we should educate them कि instead of saying I will see you in the court, we should advise them, we should guide them, we should educate them कि let us settle the matter out of court.
बातचीत कर लेते,
बातचीत करके किसी तरह से. So this is I feel कि as an advocate, even banking scenarios we are having more opportunities. Sir, इतने agreements होते हैं जिसमें सब में I advise my bank कि you should have a panel of arbitrators. आप कल को arbitrator कोई invoke कर रहे थे, आपके पास arbiter nominate करने के लिए नहीं है. You should have advocates on your panel. You should have your CA on the panel. You don't know what type of matter is coming.
अब तो एक और concept आ गया साहब, R-med. So while doing the arbitrations also, like I do, I encourage the parties to go for mediation. And if they want to use my good offices, I'm available even in that capacity. So if you settle earlier as an arbitrator also, I need not adjudicate and decide.
Adjudicate.
So you better settle. I mean, earliest possible resolution of the dispute by mutual settlement is best, even if you are stuck up in the court or you are stuck up in the arbitration proceedings, whatever. If you do it mutually, that is the best.
Best, sir. It is a win-win situation.
What is my interest and how my interest is going to be served?
No.
So that's very good. And thank you for giving a great insight into the banking sector also, which your large experience will definitely say some great authority also. Praveenji, there are some questions in the chat box. Can I just give brief replies to Mr. Rajesh Lohia?
Yes.
Mr. Rajesh Lohia, you are a company secretary.
Yes, sir. Yes, sir. I am a company secretary.
Very good. So just let me try to answer your questions briefly, sir. With the permission.
Yes, sir.
Do arbitration award need to be registered with anybody? The answer is no. There is no need to register anything. So this is clear, simple. And of course, if the award gives some transfer of property, then for execution of that conveyance, of course, in terms of that arbitral award, you will have to go for registration act and then registration will apply. Do arbitral award need to be stamped in any manner? No, again, unless there is a conveyance of the property, that conveyance requires the stamp duty. Arbitration award has exactly same effect as the award of the court. Yes, it is given the status of a decree. Now, there is one angle which I have been thinking. and this is not yet incorporated in law also, let us think out of box sometimes. If a high court judge, a former high court judge is the arbitrator, like I am in many cases, but that decree will be given the status of a civil decree only of a lower court, district court. So section 34 will lie to high court. So another high court judge, comparatively even a junior one, will be hearing the proceedings to set aside my order also or award also. So wherever the law is required to be amended if they want more quicker solutions, that wherever the arbitral tribunal comprises of a high court judge, a former high court judge or a former Supreme Court judge, then only one remedy for setting aside that should be available to the higher court, like Supreme Court.
True. Very true.
Tell the remedial steps which I have been advocating for so long, but nobody listens. That is one. Then your fourth question is, there is a compulsory requirement of attending 40 hours training for commercial mediation? Yes, the answer as of now is yes, because to be trained mediator, you have to attend a 40 hours course conducted by MCPC, constituted by the Honorable Supreme Court. But that may be replaced by another training institute in the new mediation law, which is likely to be in few months now. And of course, a training to the mediator, even as a sitting judge of Madras High Court, I have undertaken that 40 hours course along with my 26 colleagues sitting judges. And after the course, trained by senior advocates, senior trainers, etc., we felt that we are at least better judges now, even if we don't go for mediation. Right now, as sitting judges, after our retirement, perhaps we can render these services to the society. And that's what we are now trying to do also. And that's a good thing to do, really. It's a great social service. If by a mediation, by your intervention, by your experience, good counseling, good education, if the parties can settle a dispute. Recently, even NCLT referred a matter to me for mediation. Two groups in a corporate fight were going on. So the Honorable Chairman thought that I, being of this subject, perhaps can help them in resolving the dispute. That is pending as of now. So any stage, everywhere, in all kinds of civil dispute, mediation is possible, should be encouraged. It's a question of mindset, which we professionals, being CA, lawyers, or whatever, should be knowing the procedure, basic procedure, and then getting the matters referred to these ADR system. If a complete drive or a march or movement of this ADR system is made, I believe Indian legal system, even with the present strength of the judges, 20,000 civil judge to Supreme Court judge included, can cope up with this 4 crore cases, half of which can go away. So somebody on these broad lines should really frame policies. Litigations policies are framed by government departments, but they do not follow, except for the withdrawal of the cases, but a particular limit. 20 लाख से ज्यादा आपको हाईकोर्ट में नहीं रखना, आप विड्रॉ दे दो, 1 करोड़ से कम कर दो. अब उसमें क्या क्वेश्चन है, क्या नहीं है, कोई दिमाग लगाता नहीं. सबसे ज्यादा प्रॉब्लम ही दिमाग होते हुए भी नहीं लगाने की है. Human beings are the best brains, but how to apply, where to apply, is unfortunately not trained for this purpose. That is and thanks to the organizers here who are conducting these kinds of webinars, where people from different backgrounds like you and me and Mr. Srivastava and Dukia Sahab can come and share their experiences and really educate the people that here is a system, alternative system, which is of much value to all of you, and you can definitely avail the services of trained people there. So thank you so much, and I think we are nearing the end of the session, sir. What do you say?
Sir, my last
I will
question.
take a minute. I will take a minute.
Sir, my last question. One question.
Our litigation policy.
What question, sir? What questions remain, Mr. Rajesh?
Sir, my question is, Mediation Act is pending before Parliament after Standing Committee report. So, are we expecting next session it to be passed?
Hopefully, yes, depending on the list of business which they have, but it is now driven, and we have also sent some, discussed in various seminars. Our inputs have gone there. Now, Parliament's list of business is a very tricky thing. So let us hope for the best. It is awaiting for last now long 1 or 2 years. So I think
Definitely. Thank you, sir. Thank you very much.
Thank you, Mr. Rajesh. Yes. Is anybody else any questions, sir?
Sir, one more question in this.
How to
challenge.
challenge the arbitral award, sir, if the two parties are not agree?
Award procedure is there in section 34 of the Arbitration Act. Limited grounds, breach of natural justice, party not being given appropriate opportunity, etc., or the arbitral award touches the points or issues which are beyond the contract itself. These are limited 2-3 grounds on which section 34 petitions can be filed in the court. And if the lower level of court decides against that, then section 37 provides a further appeal in the same court, intra-court appeal. These are the only two ways of challenging.
So there is a very limited ground of appeals in the to challenge the award,
हाँ,
sir.
बिल्कुल, बिल्कुल,
Isn't it a very
limited
risky
रखा
that
गया है.
if I'm getting into arbitration that I am bound by the whatever all the considered whatever the all the factors which has been considered by the arbitrator?
You cannot challenge the award on the merits. Suppose आपको 10 लाख का कंपनसेशन चाहिए था, आर्बिट्रल अवार्ड ने कहा नहीं मेरे हिसाब से 12 लाख किस हिसाब से बनता है, तो उसको आप चैलेंज नहीं कर सकते 34 में कि भी आर्बिट्रेटर ने 12 लाख क्यों कह दिया. ये नहीं कर सकते. आपकी प्रोसीजर्स में कहीं अगर ऐसा लेक्यूना रह गया जिससे आपकी अपॉर्चुनिटी ढंग से नहीं मिली है, तो आप उसको कह सकते हैं. या जैसे आर्बिट्रेटर बायस था, उसके पास कोई रीजन था, कोई ऐसा मटेरियल मिले जिससे आर्बिट्रेटर की बायस प्रूव हो जाती हो, तो
Yes,
पूरा
sir.
अवार्ड चला जाए.
Great. Sir, one last quick question. Sir, mediation में जो settlement होता है, sensitive बता दीजिए how to have the sensitive. That's it.
मीडिएशन में
Mediation की जो settlement होता है उसकी sensitive. एक तो contract से आ गई या फिर we go to the
सेंसिटिव सिंपल है. आप इवन प्री लिटिगेशन भी आपने अगर कोई मीडिएशन का सेटलमेंट कर लिया है तो कंसर्न सिविल कोर्ट में जाइए, वो उसको टप्पा लगा के डिक्री बना देंगे. और अगर ड्यूरिंग द कोर्स ऑफ कोर्ट प्रोसीडिंग्स आपको मीडिएशन में रेफर किया गया है और आपने सेटलमेंट कर लिया है, वो उसी कोर्ट में जाएगा. उस टर्म्स में सिर्फ वो देखा जाएगा कि ये कोई अगेंस्ट पब्लिक पॉलिसी वगैरह तो चीज नहीं है, ऐसी कोई बात इलीगल या कोई क्राइम करने की बात तो सेटल नहीं कर लिया आपने. उन बातों को छोड़ करके वो कोर्ट उसको सेटलमेंट को डिक्री बना देगा, which will be binding for all times to come.
Thank you, sir. Thank you so much.
Yes. Yes. Any other doubts, questions?
Hello, good evening. Good evening, sir.
Yes, Mr. Sunil Singh, I can hear you. Yes, please speak.
Sir, I'm a fresh graduate. So I had a little doubt with respect to the overriding effect of MSMED Act and the Arbitration Act. So which one would prevail in case a party puts an arbitration clause in the agreement itself, stating that we will resolve this particular dispute under the Arbitration Act. However, in the MSMED Act, the arbitration is mandatory.
You are talking about MSME Act, medium and small scale industries, na?
Yes, yes, sir. Yes, sir.
Yeah, you are talking about that. There is I examined this issue recently. There is a
Yes.
provision in that act itself that even the MSME council, they will try for conciliation first and then adjudicate the issue themselves. And if they cannot adjudicate themselves, they can refer the parties to arbitrator from there. So MSME has an outlet to arbitration in the act of MSME itself. But if they decide there itself, then that is binding in the parties. So there is no conflict of.
Okay, so in case
there is no conflict of two enactments, please. Yes.
Okay,
Yes.
sir. So in MSME Act, the conciliation is mandatory, before resorting to arbitration. However, in under Arbitration Act,
हाँ, बोलिए.
yes. So they will have to go under MSME Act first, right? Then
If they are covered by the definition of MSME, they should first go there. And MSME Act is a very good act which provides in-house conciliation, in-house adjudication by MSME council, which is headed by an IAS officer. And the 2, 3, 4 members sit there, they try to resolve the dispute and they can pass a decree. That is binding. The other judgment debtor will be bound by that. If they cannot resolve, then the way out for the MSME council is to refer the matter to the arbitration under 1996 Act.
and in that case, if arbitration, they can again go for conciliation under Arbitration Act.
No. That procedure is over. Conciliation part will be over. That will be then only adjudication.
All right.
Yes.
Yes. All right, sir. All right. Thank you.
Yes. अभी आप ऐसा एक और कर सकते हैं. अभी टाइम तो ओवर हो गया.
Thank you, sir.
Thank you.
And,
You can, if you have more questions, you can mail it to them. I'll try to respond.
I welcome and invite to Mahadev Birla ji. He was in practice since 2008, and main area of practice is RERA, real estate, and
Where
written,
real estate.
many books and articles on this. I request Mahadev sir to please give your guidance. Mahadev sir.
Yeah, good evening, everyone. Thank you, sir. Thank you, Praveen ji. Honorable Kothari sir, Justice Kothari sir. Good evening, Rajesh ji Lohia and Srivastava ji, Praveen ji, everyone. Thank you, Praveen ji, for giving the opportunity to have a discussion on the RERA versus arbitration. As we all are aware, now that this RERA, Real Estate Regulation and Development Act, which has come into force since 2016, and practically it was implemented in 2017. First, I will go through some basic object of the RERA and which kind of litigations comes before the RERA authority and what kind of matters comes. So this RERA 2016, the basic object of the RERA was to protect the interest of the consumer into the real estate industry and as well as to regularize the real estate sector. So the question comes before the RERA authority that whatever the grievances are there of the consumer means the allotee, ultimately the person who are buying the flats or who are buying the shops into the real estate project. So what kind of grievances there and how we can sort it out. So some grievances in respect of the refund, compensation. Some grievances are respect of the agreement to sale is not executed, sale deed is not executed, possession is not given. There is a common amenities problems, facility in respect of the project are not provided. So such type of situation arises. Now, 2016, the RERA came. Before that was also some projects, and that ongoing project was supposed to be registered under the RERA if they have not received the building use permission or occupancy certificate. So some agreements were in existence at the time of implementation of the RERA. In that agreement, there are some clauses or there may be clause in respect of the arbitration. Now, what after 2016, when the RERA came into the force and the model draft agreement to sale is prescribed or it is drafted, there is no such clause of the agreement, arbitration clause. So the question arises that when the arbitration clause is there in the agreement, whether that complaint should be filed before the RERA authority, whether the parties should go into the arbitration. Now, if we talk about the RERA, section 32 subsection G talks about the power of the RERA authority for to measure the facilitate amicable solution between the parties, and that may be through the association formed by the allotee or the association formed by the promoter. So there is a provision under the RERA. Now, but in addition to that, there is a provision under section 79 which bar the jurisdiction of the civil court. Now again, if we talk about the section 88, which say that this provision are in addition to the other law. So the confusion arises whether the parties can go in the arbitration or not. Recently, in the one of the judgment, Honorable Bombay High Court has held that if there is an agreement where the arbitration clause is there, then section 79 of the RERA is not applicable and the parties can go before the arbitration and they can mutually settle the award. Another question comes when we talk about the RERA disputes, whether this arbitrator tribunal is the civil court or not. Because ultimately, if it is a civil court in the nature, then obviously section 79 would be applicable. So these are the questions where we can highlight the applicability of the arbitration clause under the RERA and what would be the consequences. Now, because if we talk about the provision of section 31, which talks about the RERA that the complaint can be filed before the authority. However, there is no timeline. If a complaint is filed before the adjudicating officer for the compensation under section 12, 14, 18 and 19, then there is a timeline of the 60 days. If we talk about the allottees, when they are not rich, they cannot afford the cost, then whether the arbitration clause should be included in the agreement to sell, because the main matter before this Honorable High Court is that the all state should implement, or they should come with the standard format for agreement to sell. So looking towards the grievances and looking towards the nature of the grievances of the customers, whether we should have an arbitration clause under the RERA or not, that is the important question. So this is from my side in a short. Now I think Nipunji is there. He will take care about the future, how that we can deal with the arbitration. And
Sir, 1 minute, please. Dr. Justice want to leave. So just thanks about and on behalf of JIPA, I give a thanks to sir very nicely and accepted and delivered very nicely our questions, answer and guide us and ensure, and we will request to support in future also. Thanks a lot, sir. We will be in touch with you later on. Thank you, sir. Please
So
carry
I
on,
think-
sir.
yeah, thank you, sir. So I think these are the main important clause as far as the RERA and arbitration is concerned. I think Nipunji will highlight some more points in respect of that. In addition to that, I would like to mention that even the Maharashtra RERA authority has implemented this section 32G, and they have formed some conciliation forum also, where any complaint is filed before the RERA authority. Generally, they refer that complaint to that conciliation forum, and that conciliation forum decides the complaint and they sorted out the grievances. If it is not sorted out, then they matter again refer to the RERA authority for the hearing and to decide the complaint as per the RERA provision. Thank you, sir. So if any query is there, please put into the chat box. We will reply.
Thank you, sir. Thanks a lot of your nice words. And I welcome and request to invite Nipun Singhji, who is also our vice chairperson of our Hip Hop Professional Association, and very nicely quoted and guide us. So please, sir.
Thank you, Praveenji. And I think we have got a great panel today. And by the insights given by Honorable Justice Kothari, we are very much enriched with the new insights into the law. And as Adukya ji said, that this arbitration is going to be the next big thing for us as a professional. In fact, I would just like to, when we were talking with the Praveenji, we were thinking of that arbitration. Probably we will today do arbitration with banking, arbitration with RERA, and then probably arbitration with other law would also be explored. So on that side, as Madhevji already told, and Madhevji and me have together written a book on RERA also, we were always exploring the thing on arbitration, whether it is possible or not. So let me tell you, friends, that though we are always saying arbitration, but we normally mean an alternative dispute resolution. So it is not only arbitration, as Kothari sir rightly pointed out, mediation, conciliation, these all are ways and means of ADR. So today there is an alternate requirement of dispute resolution. And this is basically because of the strict sense of procedures if otherwise somebody goes to court. So if normally somebody will go to court, he will have to follow a strict rule of evidence, a strict rule of procedure, and he has to go through the all procedural aspect and commercial matters. If somebody goes into this particular procedure, it is actually deteriorating the value for both of the parties. So therefore, this particular act, I would say, has become more popular. In fact, last night I was reading about arbitration, and then I understood what is the concept which internationally is accepted with regard to arbitration. So arbitration basically is a procedural law. As they say, lex arbitri. Lex arbitri basically means that arbitration will only be a procedure to solve the dispute, wherein strict sense of, I would say, evidence or CPC will not apply. So we can get arbitration done, or in a way, alternative dispute resolution done in any law. So let us take an example, which sir was saying, Justice Kothari sir was saying that in the matter of NCLT, it was referred to him. So that is how, if there are two parties, there is a dispute, and everybody knows that ultimately it would be a settlement. Like for example, in case of companies, we know there is majority minority shareholder dispute. There is always be a management dispute. It is better to get the reference to mediation or to an arbitrator so that the matter gets over easily. So there is a one section of Companies Act 442 wherein there is a mediation panel being maintained by the regional director office. In fact, retired judges can also be directly the mediator, but there is a panel also maintained by the Ministry of Corporate Affairs. So therefore, if somebody really wants to use this procedure, the time is bound 90 days only. So once you got the matter referred from NCLT for our mediation under 442, the timeline is fixed of 90 days. Both the parties can actually sit together, get a order, and as sir said, as good as decree. Yes, if both the parties do not agree, then again it will go to NCLT. But this is a very good way, good opportunity. Similar to this, I have seen another matter which Srivastav ji was telling about retired Justice Sikri, Honorable Sikri sir, who is retired from Supreme Court. He was also referred a matter of Section 7 in insolvency by NCLAT. If I'm remembering the name correctly, the petitioner name was Intech Capital, who was the financial creditor. So basically it was referred and amount was worked out, post-dated checks were given, and basically an order was passed by the Justice Sikri, being a mediator in the matter. So point is that whatever litigations we see, and most of our panelists and professionals here, they have in and out gone for company law or IBC and RERA. All these ways we are having the way out of ADR, and this can be one of the ways. As far as RERA is concerned, we have been seeing that there are disputes between builder and buyer. Broadly speaking, there are 4 types of dispute, which I understand. One is that the builder sometimes does not deliver the property on time. So whenever he promises that I will, let's say, deliver in 2020, it at least goes by beyond 1 year or 2 year, whatever is the deadline. Second issue is with regard to amenities or facilities. Sometimes he must have promised a clubhouse, a swimming pool, a garden. All these common facility or amenities are not being provided. Third is there could be a poor quality of structure or maybe construction. And fourth, and in I would say rare cases, the buyer is so fed up with the builder would ask for a refund of the money. So all these 4 types of grievances are there, except last one where refund has to be sought, which is the last resort. If disputes are relating to first 3 categories, I suggest and I always believe that we can always mediate and conciliate. In fact, Maharashtra RERA in India, as far as my knowledge goes, only Maharashtra RERA has formulated this conciliation process wherein before the matter being reaches authority for adjudication, they refer it for conciliation. So something like this should be worked out for all other RERAs also. And I have been advocating this, and we always try to mediate before the matter goes for dispute adjudication. Because what happens normally is if the matter is litigated, something would be passed by RERA, then the matter will go to maybe adjudicating officer, or in some cases they have authorized the magistrate to execute the decree. Now, once that decree is passed, then obviously there would be a challenge in the RERA appellate tribunal. Then appeal will go to High Court and then Supreme Court. So the litigation will go on. But if suppose there is either mediation or conciliation or in a form arbitration, then I think that both the parties will be satisfied rather than disputing in various forums. They will actually get to conclusion and get the payment if this is the case. I am talking mostly about the first 3 kinds of disputes wherein there is a delay, there is not fulfillment of promises, amenities, or maybe some compensation or interest. But then if the case is of a refund, then I am sure that these alternative dispute resolution might not work, because practically my experience of whatever builder lobby I have been working, whatever buyer cases I have been seeing or practicing, I have seen that if the project itself has not taken off, then the builder side or the developer side would never be in a position to pay the amount completely because the funds would have been stuck. But if there is a completion issue, I think that alternative dispute resolution is a better way out. And I think, Parveen ji, we can, in this line of ADR, next time we can think of this 442 mediation, we can call Kothari sir and explore how operation mismanagement and IBC matters can be referred to this mediation panel. So I think, sir, now we can take some queries because we are nearing completion. Jan sir? Yes, Praveen ji.
Yes, sir. Can continue.
Yes.
So, I am very thankful to Shri Dr. Justice Kothari ji, CA Dr. Rajkumar Bhukia ji, and our guest speaker, Advocate CA Nikunj Singh ji, CA Madhav Villa ji, Advocate RK Srivastav ji, Piyush Jain ji, and CA and IP ji, Mr. Rajiv Khona ji, Senior Advocate AK Chaudhary ji, CS Dholkam ji, and IP AK Srivastav ji, and all our DIPA members and participants. I am again very thankful to participate for our webinars, for knowledge sharing, and I will keep it up for future webinars. Thanks a lot, sir. Thanks, sir.
Thank you, sir.